Good morning. Happy Thursday. Part two, I guess, since I made one video earlier this morning at around 3 in the morning. I've had a lot of comments that make me feel like I should address them because I keep seeing the same thing kind of over and over again, and they're sort of related. They're half related. One is essentially, why doesn't the judge just watch Chili's videos and then the judge will know that Chili's an a-hole and he's a terrible person? And the reason why is because that's not the judge's job. In the United States, the judge's role is to rule on the facts that are presented to it. If it's a bench trial and for motions. If it's a jury trial, it's just to assist the jury with determining what the laws are and what elements are relevant. But in a bench trial or in a situation where there's a pending motion, it's not the judge's job to be an investigator. In fact, there was that case out of, I don't know, somewhere in like Tennessee or South Carolina or something like that, where a family court judge was going to homes of litigants to investigate to make sure that certain things were being done in a certain fashion. That's not the role of the judge. The judge is in the courtroom to judge the evidence that's placed in front of the judge. Additionally, most of Chili's videos are not relevant to the current proceedings. You have to remember that the scope of the lawsuit is based on the pleadings that are in front of the judge. That's what's in front of the judge, the pleadings. The complaint, Chili's complaint, Kate and Josh's counterclails, those are in front of the judge. Those are the bounds of relevancy. Those are kind of those are what the roadmap that are going to be guiding the litigation. Those determine what is and isn't relevant, what should be and should not be taken into account by the finder of fact. So right now, what Chili has placed in front of the judge is his second amended complaint, which he titled a supplemental complaint, where essentially he just names YouTube and alleges causes of action against YouTube. So that's all that's in front of the judge right now. Any video that Chili made about how he's trying to drag Kate and Josh through the mud is not relevant to that complaint. And Josh and Kate's counterclaims, they're only things that are, I think they sued for defamation, only things that are specifically defamatory about Kate and Josh are going to be relevant. Only that. Anything about him saying that he's going to drag out litigation or sue everybody or just be a general jerk, I mean, not relevant. Not relevant. Now, would a attorney try to get that stuff in front of the judge? Oh, hell yeah. I mean, you want to try to prejudice the judge against the opposing party, but it doesn't always work and it's not always easy. And judges show a lot of restraint, which brings me to the related point of when people ask, when is the judge going to just get tired of all this and toss the case out? Well, never. Theoretically, it's possible to get terminating sanctions. Terminating sanctions are where the judge says, because you have been so bad, I am going to dismiss your claims with prejudice. That's a terminating sanction. I've never seen that happen. It is possible. It is theoretically possible, just like it's theoretically possible that Chili could get extradited on a misdemeanor warrant to Ohio. But terminating sanctions are even less likely than Chili's extradition, which is already insanely unlikely. It's not going to happen. You wouldn't go to the horse races and bet on that. You know what I'm saying? Like Vegas odds would be in the kind of winning the lottery range on either of those. Just really, really even more unlikely on the terminating sanctions. You've seen the way this judge has been handling it so far, and this judge is not outside of the realm of normal. I have very limited experience with judges even discussing sanctions in federal cases. I have significantly more experience with judges discussing sanctions in state law cases. But judges are judges, and the judicial canon for ethics is the same pretty much for any judge. Pretty much. I mean, there's going to be some minor differences, but generally speaking, judges have to act like judges. And one of the things that they do is they show a lot of restraint, and they give people lots of chances, and they are slow to anger. You really have to be a bad person. You really have to be doing bad things to start getting monetary sanctions. It takes a lot to have a judge issue a monetary sanction against you. And the next step from there is very rare, and that's where you start getting issue sanctions or evidentiary sanctions. Like if you're being really bad about discovery and you're not turning over discovery, the judge can say like, okay, well, we're just going to assume that discovery is bad for you, and we're going to give an order to the jury saying that discovery is bad for you, and the jury should infer that discovery said what the opposing party said it would say, that you're a terrible person who did terrible things, or that you can't prove a particular thing using that evidence because you never produced it. Something like that would be an evidentiary sanction or an issue sanction. Issue is slightly broader than an evidentiary sanction. Issue sanction means you just lose on that issue. That issue has been determined against you because of your bad actions. And then finally you get to terminating sanctions, where like the whole shebang, your lawsuit's done. It's not going to happen. And I know everybody wants it because you hate chili, but that's just not the way it works. Like, it's not gonna happen. Chili would have to continue doing things like this for quite some time before it even gets close, before the judge even starts thinking about terminating sanctions. Because you have to remember that Chili is pro se. And so he is going to get some leeway if he appeals. And you have to remember that a terminating sanction is appealable. It's directly appealable. You can appeal it without having to ask permission of the judge at the district court level to appeal a terminating sanction, because that ends your lawsuit. So you get to appeal that. And judges tend to want to advance their careers. So this judge is probably hoping to eventually be appointed to a circuit court position. Maybe even from there to a Supreme Court position. That's the career trajectory of a federal judge. And being overturned, especially being overturned a lot, but being overturned can hamper that particular career goal. So I'm not saying it would be fatal to a judge. I'm not saying judges care all the time, but it's something that judges have in the back of their heads. So those are the two kind of overarching things that I get a lot of in my comments. So I hope you understand that, number one, the judge is not going to go out and investigate Chili. The judge is going to limit her inquiries, her investigations, to the facts that are presented to her. She's going to examine the documents and the exhibits that are presented to her. That's the extent of her investigation. And number two, terminating sanctions aren't happening. I mean, you will have a lot of notice because there's going to be a lot of steps. You're going to see money sanctions first. You're going to see issue sanctions before you get to terminating sanctions. It's a long road to hoe in order to get there. Now, on an entirely different topic, I have been accused apparently of desiring for a mistrial for Earl. I don't know why anyone would accuse me of that. I have, from the very beginning, hoped and prayed that Earl gets the fullest and fairest trial possible, which will eliminate any needs for appeal and will give finality. I want this done on the merits. I would like to know a result. a good result, a result that is done with a full and fair trial. Now, I don't have any particular investment in this. Earl might be innocent. He might be guilty. I tend to believe he's guilty, but that's just a belief. I have no knowledge that he's guilty. I have no desire to send, if I was going to send someone to contaminate Earl's trial, I would not send the crayon eater, Dougie, the crayon bandit, the guy who showed up at that at Texas open carry event in a bandana with crayon scrawled pamphlets that were misspelled, who ended up peeling out of there and getting a ticket. That is not the guy I would send if I was going to send someone. I just want to be very clear about that. I'm not sending anyone. I would not send anyone, because you have to remember that you're not hurting Earl so much as you're hurting his victim, or his alleged victim, because his alleged victim has a right to have that trial. You're hurting her. So if Dougie, if you're watching this, if you could pull your head out of your ass long enough to get a hint of oxygen to your shriveled brain, your smooth brain, stop effing it up for the victim, you nunts. Ugh! Fucking that idiot. I hate people like that. I hate people like that. Dougie is the same guy. He wrote letters to the judge in OG2's case. Like, you knuckle dragging moron. I swear to God, if I could slap the shit out of you, I would do it. You are Doug. If there is a God, Dougie will be charged with jury tampering. If there is a God, you can't do what Dougie's trying to do. So I hope to God that someone in Texas pulls their head out of their butt and goes after Dougie and people like him who are trying to tamper with the jury. That's a crime. They need to stop. Someone needs to stop them. Someone needs to enforce the law and stop people like Dougie from doing what Dougie's trying to do. I hate that dude. But anyway, if you think for any reason that Earl's telling the truth about me and Dougie, that's fine. You're entitled to it. Consider the second half of his video this morning, where he accuses Shell, the police, the oil refinery, the FBI, the CIA, the KGB, everybody of being after him. He has all of these excuses of people who are after him. And this is just purely retaliatory. Remember that his daughter made the complaint in the mid-90s. In the mid-90s. The complaint was made and the investigation was started in the mid-90s. Earl was not an activist then. He was just some pissant felon who's out on parole for rape and a weapons charge, I think. So unless you're accusing the Deer Park Police Department and Shell of having a crystal ball and of starting this plan, this retaliatory plan against Earl in the mid-90s, and number one, they were so prescient that they started it in the mid-90s, and number two, they were so incompetent that they lost the file until like 2016, 2017, when they rediscovered the file and started the investigation up again. So which is it? Are they super prescient with a crystal ball where they know to start this case against Earl in the mid-90s? Or are they super stupid and lost the file until 2017? Which is it? You can't have it both ways. If Earl's lips are moving, he's lying. And, I hope to God he gets justice. Whatever that justice is, I hope he gets justice. I know I've said repeatedly we have a legal system, not a justice system. If we had a justice system, he would have been stopped before he did any harm to his daughters. If we had a justice system, he would have been stopped in the mid-90s. But we could still get something, some scrap, some shred of justice. And if Earl is innocent, we can get that put to bed as well. Because that would be nice to know. I would like to know if Earl's innocent. I would like to have some reassurance of Earl's innocence, because then I would feel better about him walking in society. And I would feel better knowing that he has access to his grandchildren if he's innocent of the charges, if he's not molesting minors. That would be great to know. So if anybody sees Dougie at that trial, I would recommend you keep a close eye on him and maybe inform the sheriff there. Pull a Karen. Let the sheriff, let the constables, let everybody know that guy was a jury tamperer. If you see anybody else trying to tamper with the attorney or with the jury, let the court know, let the bailiffs know, let the constables know. Don't let anybody get away with that. That harms the victim. That harms the victim. Who cares about Earl? It harms the victim. Don't let that happen. Thanks for watching. Have a great day.